I announce my humble appearance for the appellant in this matter, and I appear with my learned friends, Cynthia Okezie and Awal Abdul Aziz. We both announce our appearance for the appellant. We are most obliged, sir. Abdul Aziz, sir. Awal Abdul Aziz.
Yes, respondent.
All right. So the respondent is visibly not before the tribunal.
Yeah, any party rep or appellant?
Yes. So yes, we have party reps. We have Mayowa Begunde, who is the head of Treasury for the appellant. Abegunde. Yes, sir. If Mayowa Abegunde can unmute and on his camera too.
Yeah. Good morning, Neriden. Yeah. Good morning, everyone.
Your designation, please.
Okay. Yeah, I work as tax and treasury supervisor.
Not head of treasury.
Yes. Tax and treasury supervisor.
Because of that bad road now.
Yes,
All right. I think this matter ordinarily was supposed to be for adoption of final address. All right. However, due to circumstance beyond our control, we just filed our reply on point of law. This morning, we sincerely apologize for that. It was due to some internal issues that was beyond our control. Right. So on this note, we most likely will be asking for another date to enable the respondent have the benefit of the doubt to see the copy of the reply we filed. And also adopt same on the next adjourned date. We would have loved to make an oral application for the said reply file out of time to be regularized, but they are not before the tribunal. So I don't know if the tribunal can adjourn for us to make that oral application and also adopt our final address on the next adjourned date, sir.
I think the second legal is put out this last one, so it's better. It's better, that's regularly, they don't have right of reply to return. Yeah.
We are most obliged, sir.
Except that it was so out of time, if not, would have adopted, would have gone ahead the adoption.
We are most obliged, sir.
Yes. Okay, sir. You want to what is? That's true. You want okay, this is several. It's short of. So go then. Go down. Short of. I mean this one, but that's not. Everybody. Now we'll get it. 11th.
11th is convenient, sir. 11th is convenient, sir.
There is one of us. This case is further adjourned to the 11th of August 2026 for adoption of final written addresses. Hearing
As the
notice is served for the respondent.
tribunal pleases. We are most obliged, sir.
For the motion.
Number 2 on the person that P number C80/LLF 1 right? State Center DCC Building Limited of the Board of Internal Revenue.
References?
All right, with profound respect to the tribunal, my name is Nuruddin Aziz. Appearing with me are my learned friend, Cynthia Okezie, and Awal Abdul Aziz. We humbly announce our humble appearance for the respondent.
You are appearing for the respondent.
Are they online?
Sorry, for the appellant, sir. For the appellant. Yes, we have Mr. Mayowa.
Are they online?
Yes, they are online, sir. We have Mr. Mayowa, which is the head of treasury, and we have Oluwadamilare Asuni, who is the witness on record, sir.
That's representative for the. Where are they? I can see Cynthia. Where is Abdulaziz?
Abdulaziz is online also.
Let him on mute. We can't see him.
Get the more
Mowan is no longer with us, sir. Mowan is now with Banwa Nigodalo.
No one at the camp.
Okay.
Yes. Mowan is now with Banwa Nigodalo. Maybe we can. Yes, Mr. Mayowa is online. If you can unmute and.
Yeah, good morning, everyone. Yeah, my name is Bayawa. I work as tax and treasury supervisor.
You mentioned another person.
Mr. Oluwadamilare Asuni, who is the witness on record, sir?
Is he representing your witness?
Yeah, he's a witness. He's not representing the company, he's just a witness, sir.
So, are you aware of the letter from your?
Very well, sir. A copy of the letter was shared with us yesterday. We do not have any objection to the said letter. It is unlike them.
Let's have it down. Let's take it down.
All right, sir. So the matter is adjourned today for continuation of cross-examination of the appellant witness.
Yes.
The matter was adjourned on the last adjourned date for the respondent to serve us a copy of a document they intended to admit through the appellant witness.
Copy of the document.
Yes, they intend to tender a document to our witness, which the tribunal, in its wisdom, ruled that the said document, a copy of the said document, be shared with us before today's date.
It was the appellant who undertook to produce the NPA green lights of
Yes.
The appellant undertook to produce that.
Yes, we also undertook to produce some documents, which the said motion, we were supposed to file it yesterday and serve it, but the moment we received that document, we didn't want to bore the tribunal, but we are going to ensure we file it today before close of business. The respondent were also supposed to serve us a document, sir,
which are not before the tribunal. Is there for order to furnish the tribunal with the documents in accordance with the rules? The tribunal, that's the respondent.
Yes, sir. So, however, because of the letter before the tribunal, we would be conceding to another date so that all of these documents would have been filed and would have found their way into the record of the tribunal, sir, before the next adjourned date.
What's that like? Sorry, as I say that. Yes, what is?
All right, subject to the overriding convenience of the tribunal.
Also that is. Yes. 11th?
11th is convenient too, sir. 11th is convenient.
This suggested it is.
No, they didn't suggest any date.
It is further adjourned to the 11th of August 2026 for the continuation of resolution of the appellant's witness. Hearing notice is ordered to be served for the respondent.
As the tribunal pleases, we are most obliged, sir.
Number 3 on the cost list with appeal number T80 /2023. That is Chevron Global Services Limited versus Akwa Ibom State Internal Revenue Service.
May it please this honorable tribunal. My name is Nuruddin Aziz. I appear with my learned friends, Cynthia Okezie, and Awal Abdul Aziz. We announce ably for the appellant in this matter, Honorable Chairman.
Respondents, no? Yes, still letter. Any party rep?
No party rep, sir. No party rep.
Yes.
All right, my Honorable Chairman, the matter is adjourned today for defense.
For defense or was examination? No cross-examination of special witness.
Yes, like because of for defense of their, like they are still in their defense. We're supposed to cross-examine their witness, sir.
The information of the respondent witness by physical witness. was for presentation of respondents' witness.
Very well, sir.
So,
So on the last day, my lord, when the matter came up on the last day, we made some series of application.
yes,
Among which is an order for foreclosure. Among which is an order for foreclosure.
yes.
And also, we also made an order before the Honorable Tribunal to discontenance with the already given testimony which has not been subject to cross-examination of the respondent.
You have comments.
Yes.
How do we discontinue?
So they requested that so they undertook to provide some documents which they admitted under their cross-examination.
Your presentation. So the presentation that you did is still part of the records.
As the tribunal pleases, so we will be asking for a foreclosure order today, my Honorable Chairman.
Yes,
As the respondent cannot and will not continue to hold this Honorable Tribunal to ransom as a result of their non-appearance.
yes.
The tribunal on the last adjourned date magnanimously grants today's date. The tribunal magnanimously grants today's date to give the respondent another fair hearing opportunity.
Yes.
The tribunal further ordered that a hearing notice be served on them for them to be aware of today's date.
We can go decide.
Yes.
Okay.
When we received the hearing notice, we also took the leverage of sharing the copy of the said hearing notice with the respondent counsel through its WhatsApp number.
Yes.
This was done on the 6th day of July, 2026, just to further intimate them of today's date.
Yes.
However, the respondent has willfully, intentionally, and intentionally refused to appear before the tribunal today.
Yes.
All right, so on this note, we will be invoking the provision of Order 7, Rule 8, Order 9, Rule 3, Order 17, Rule 1, which gives the tribunal power to conduct its proceeding in the manner it deems fit.
17.
Rule 1.
Yes.
Order 17, Rule 4 also.
Yes.
And Order 11, Rule 1, 2, and 6.
And 11.
Rule 1, 2, and 6.
Yes.
As the respondent cannot continue holding the tribunal to hostage.
I presume the others recited are from the
Which
safety
rules?
rules.
Which rules? Which
The
rules?
Tax Appeal Tribunal Rules 2021, sir.
That's what,
This is the question I was asking you. But there are so many others, several rules.
So sorry, sir. We are properly guided, sir.
Yes.
On this note, we'll be asking for a foreclosure order against the respondent and a direction that the parties are directed to file their respective final address.
Aziz,
We are most obliged, sir. Thank you, sir.
because matter keeps coming up for continuation of presentation of the appellant's witness. So if we are for closing, you are saying we should foreclose and then other final written addresses.
Very well, sir.
We are for closing. What happens to opportunity to the respondent provide their defense?
So the defense is not absolute, sir. What the law provides for is an opportunity. If the law had given them the opportunity,
We have not given them opportunity to defend.
no, they have, sir. They have,
give
sir.
the opportunity to cross-examine your witness.
No, sir. So the fact that they are already defending their case, it means the tribunal has given them the forum to do so.
To cross-examine.
Because yes, because I'm sure the tribunal can check the checked time when this matter came up. And the tribunal can also make inferences from their conduct in some other sister cases, where we had cross-examined some of their witness when they were supposed to provide evidence. Their witness becomes incommunicado. In fact, when Lawrence Etekudo was supposed to come and continue his cross-examination, we just discovered that they said it was no longer reachable or has been transferred from that department, which allowed the tribunal to give them more leeway to change their witnesses, which they have changed. Now the witness came on board, cross-examined, couldn't answer some questions, and the tribunal gave them an opportunity to provide those documents and come back. And since then, that witness has also gone AWOL, which is available absence without official leave. Let me paraphrase her. So the tribunal has given them the opportunity to present that witness. It is now left with them to make use of that opportunity. And if they have refused to make use of that opportunity, the tribunal cannot be held to have not given them their right under the law. And even the tribunal adjourning the matter to today's date, my Honorable Chairman, was also part of that opportunity that was given to them. In fact, the tribunal awarded the cost of 300,000 against them. Immediately after the proceeding, I sent them the decision of the tribunal on that day and the amount. I also forwarded the account number of the appellant to them, whether they are going to do the needful. The message was read, they never acknowledged, and they never confirmed receipt. The same thing with the hearing notice. So I feel what the tribunal is supposed to do under the law has been done, and we cannot allow them to hold us to ransom. It is obviously they are not interested in the appeal. I'm not trying to delve into the subject matter. It's also obvious that they know that the best of judgment assessment they have raised cannot be substantiated. If not, why are they not before the tribunal today? So they can come back if they feel they still have rights, if they feel they want to come back. They can come back, they can file a motion before the tribunal. And if the reason provided in the affidavit is cogent enough, the tribunal still have the right to give them that opportunity. But we cannot allow them to keep holding us to ransom in as much as the tribunal has served them a hearing notice. And we urge the tribunal to humbly grant our application, sir. And as a matter of fact, the Honorable Chairman we agree that it is strange for us to always appear virtually. It was because this matter has came up over 5 or 6 different times that our client has expended money and we have expended time in coming to Benin. And based on the non-availability of the respondent, this matter has suffered series of adjournments, sir. And I am sure the record of the tribunal will speak for itself.
I just, can you read that on the 903?
Want to find.
You cited on the 9. Can you read that? On
Yes.
the 9?
Among some of those others that we cited was order 903. I'm coming, so.
Yes.
All right.
Very-
IV.
Can I go ahead and read it?
Yeah, you can go ahead and read it, Cynthia. I'm trying to open it virtually through my system.
So order 9 rule 3 of the TAT, if on the day of hearing or on any adjourned dates, the appellant appears, the tribunal may, whether the respondent appears or not, proceed to hearing or further hearing, and determination of the appeal shall give its decision according to the merits of the appeal, provided that the tribunal is satisfied that it is in the interest of justice to proceed with the hearing under the circumstance.
What do you understand by that rule, Alice?
All right. So the principal provision governing the current situation, of course, is that order 9 rule 3 of the Tax Appeal Tribunal, which provides that where the appellant appears on the hearing date or on the adjourned date, the tribunal may, whether or not the respondent appear, proceed with the hearing and further hearing and determination of the appeal. So we have done hearing. In fact, today's matter is a further hearing because they have refused to present their witness. And if eventually they still refuse to appear, then the tribunal is empowered to give an order to determine the appeal. They cannot keep us at ransom. The tribunal has given them the opportunity. So the conditions contemplated by these provisions are fully satisfied, sir, because the appellant is present and the respondent is absent. That is one. That the matter is before the tribunal on the said adjourned date, which is today. That the respondents were duly served, which the Honorable Tribunal had confirmed from the registrar, and that the appellant had already concluded its evidence, which the record of tribunal will speak to. The respondent also repeatedly failed to proceed, which it is one of what we are faced with today. And further adjournment would have occasioned expense and unjustifiable delay. So I would have loved if the tribunal can look at the record of the court and see when we have appeared before the tribunal and they had refused to appear, and whether or not the tribunal has adjourned this case either on in our favor or in their favor. The tribunal will agree with me that dates were as a result of their absence, as the appellant had always consistently appeared before the tribunal. And whenever we don't come, which it is not within this material point in time, we usually notify both parties so that the other party would not waste time in coming to the tribunal. I think the record of the tribunal will speak to this, sir. And the rule specifically also, the rule 9, expressly permits this Honorable Tribunal to proceed, notwithstanding the respondent absent. And that is our application here. And off record, Honorable Chairman, I can tell you for a fact that we have spent, despite the fact that the appellant is position is nil position, that we are not owing the respondents. The appellant has spent over, aside the professional fee, they spent over 20 million ensuring that they come to court on every date since 2014 till date. We have consistently filed, or 2015 to date, we have consistently appeared before the tribunal. We have spent a lot of money and a lot of resources and a lot of time. So it is the tribunal adjourning this matter is not just justice being done to us, but rather being fair to the respective party in the circumstance. If not, when they received the hearing notice, if they would not have been before the tribunal today, they would have written a letter just the same way Bayelsa State Internal Revenue Service wrote a letter to the tribunal, sir. We are most obliged.
Did you say 2014? This matter has been on?
filed. I think it was filed within that period, but I think the tribunal had not been constituted as at that time. It was when the tribunal was constituted.
2023, Nudin.
It was even
2023.
2023. Oh, is it
Yes.
2023?
Well,
So when it was,
Alice,
yes, sir.
I think this case has been coming out for cross-examination of the defense witness. I think so. You are aware of that?
That has been coming up for what, sir?
Examination of the defense respondent's witness.
Yes, sir.
No?
Yes, sir.
The respondent witness testified on the 15th of April.
Yes, sir.
Testified on the 15th of April. And the tribunal ordered, because we had issues with the virtual hearing. So by consent of both parties, case further adjourned to be heard by physical appearance of parties. The 20th
Yes, sir.
of May is for consideration of examination of respondent's witness.
Yes, sir.
On 15th of April. The 20th of May, there was a letter you reported, we received a letter for adjournment from counsel to respondent.
Yes, sir, but we were physically present, sir.
This was adjourned to 17th of June.
Yes, sir.
In June, the respondent was absent or represented. This was adjourned. And you say you were prepared to go on, and the respondent once again was first. You made a long submission
Yes, sir.
on 17th of June.
And the court awarded costs in our favor, sir.
That was when we were awarded funds.
Yes, sir.
So now you say with your populace, against at the stage we were, it was for condition of the opponent witness.
Yes, sir.
That's from 15 the testimony of the they didn't come. They didn't come. Today is the fourth day, they are not even there. Because the way to us, and they are not there, no notes, no projector, no three adjournment. We don't close them. You still come, they come, we don't. Sometimes we never give this impression that we're saying. Because they give to the police. Yes. We will get started with the Yeah. What I was saying,
When is that kind of flat? That kind of something. No, September. They have this goes over the seventh. So, focus on the. Which, July, September 14th. We have been 60 days. September 60 days. Yes. Yes. You said seven, seven, this, what is it? They will check. That's an equinox in stars of so you can be tense, you can be head. We have listened to the submissions of counsel to the applicants, urging this tribunal to foreclose the respondents. This case came up consecutively on the 20th of May 2026, 17th of June 2026, and today 14th July 2026, for the continuation of examination of the respondent witness, Mr. Samuel Eseme Okori. The respondent was absent and not represented for this 3 consecutive hearing dates. The respondent did not also communicate with the tribunal to explain his absence. We agree with counsel to the appellants that this tribunal cannot and should not continue to indulge the respondent who has consistently been absent from hearing and never deemed it necessary to communicate with the tribunal. Consequently, and in furtherance of the above premise, this tribunal makes the following orders. A. The respondent is foreclosed from further defense of this appeal, present his witness. B. The appellant is ordered to file its final written address within 30 days effective from today. C. After service of the final written address of the appellant on the respondent has 30 days thereafter to file its final written address in response to the appellant. D. This case is adjourned the 15th day of September 2026 for the adoption of final written addresses of the parties. And the tribunal closes. Hearing notice. Hearing notice is ordered to be served on the respondent.
As the tribunal pleases, we are most obliged for the ruling of the tribunal. We are most grateful. Thank you very much, sir.
Yeah, that's yes.
Yes, sir.
No, probably sure.
The last one, the court is appeal number TAT/SSS/024/2023. Chevron Nigeria Limited, was Delta State Internal Revenue Service.
This case came up yesterday for hearing, and the appellant's witness started her testimony. The appellant sought for and was granted an adjournment to be able to file an application for amendments to this appeal. This appeal had earlier been adjourned for hearing yesterday and will be continued to date. In view of the intervening circumstances of yesterday, the hearing of this appeal cannot continue today. The case is therefore adjourned to 11th August 2026 for motion and continuation of hearing.
As the tribunal
As the
pleases.
tribunal pleases.
Yes. The tribunal shall now rise, please.
What's supposed to start?
Gentlemen,
All right, thank you very much, sir.
Madam Cynthia, Mr. Rudin,
Good to see you. Good to see you.
Mr. Luchu.
Good to see you.
Thank you very much, Mr. Jonathan. Thanks so much for the process that you filed.
Thank you.
Why did you say that?
Goodness. Nothing for the reading.